Understanding medical malpractice lawsuits. The question of this article was, what is malpractice? Medical malpractice claims are based on the legal theory of negligence. There is a more than 50% probability that the professional negligence did occur based on the evidence presented. The physician defendant had a duty to the patient to render a non-negligent care, a breach that the duty by providing negligent care, this breach proximately caused the injury or the damage, and the patient suffered an injury or a damage. For the breach of standard of care, what is the standard of care physicians must adhere to or to considered in a breach? Some states attempt at legally defining the standard of care, and others allow their respective state court to define it. And also, even if the parties can agree upon a legal definition, the standard of care is usually not a straightforward issue. Most malpractice cases are heavily reliant on medical expert testimonies to determine this professional standard. Medical experts in the court may testify on the standard of care despite never having treated this condition, affiliating the patient as long as the expert has a general experience with the clinical issue and causation. Also, they do not need to be in the same specialty as the defendant nor the physician, even when the physician is the defendant. Finally, some state courts have embraced a more differential approach to physician clinical judgment as found in their respectable minority role. The causation finding a proximate cause requiring showing such a harm to the patient would not have occurred but for the action of the physician. Practitioners should be aware that the patient need not to show the physician's action were the sole cause of their harm. However, liability will be reduced for the physician if the patient contributed to their own injury by acting unreasonably. Avoiding the lawsuits, there is no surefire way to prevent the patient from suing a physician for a medical malpractice. Many health systems have implemented the communication and resolution programs and referred to as the CRPs, including that the healthcare organization and the clinicians to be transparent with the patients around the risks and adverse event, create an action plan designed to prevent the recurrence of the adverse events, support the emotional needs of the patient, family, and the care team, disclose error, and protectively and promotely offering financial and non-financial resolutions, and also educate the patients and their families about their right to seek legal representation, work collaboratively with other healthcare organizations, and constantly assess and reassess the CRP's effectiveness. For the lawsuits process, learning can help the physicians manage their stress caused by the surprise associated with the medical malpractice suits. There are some general steps, which including the following: the pleadings and initiation. The pleadings are a court-filled documents setting forth each party's position. They are including the patient's complaint and summons and the defendant answers. The meeting with the attorney. Once served, the physician and the attorney will investigate the claim, determine strategy, and draft a CNS answers. The judgment after completed the pleadings are filed, many states allowed either party to move for judgment on the pleadings, which will allow for a rapid resolution if a case is successful. Discovery. Both sides engage in discovery, that is, pre-trial examination of witnesses or documentations and requests for admission. The trial. After discovery, if either party requests a jury, one will be implemented. And there is finally the appeals. A party may generally appeal once as a matter of right. The appellate court reviews considered the trial record, summaries, and attorney oral arguments focusing on legal errors and issues. And then the decision will be issued. However, the court acceptance and is rarely granted. Although only 5% of the malpractice suits reaches a judge, understanding and preparation for the possibility of a medical malpractice claim is an essential element of practicing modern medicine.